I am the director of the Castan Centre for Human Rights Law, and I'm joining you from Monash Law from our city chambers in Lonsdale Street. I hope you all can come one day and visit us here in the city. I'm very pleased this afternoon to be joined by a very special keynote address, our second keynote today. Our keynote this afternoon will be addressing Australia's place and performance in the global struggle against torture. And in delivering our keynote this afternoon will be Dr. Alice Edwards, who is the Special Rapporteur on torture and other cruel, inhuman or degrading treatment or punishment from the UN Human Rights Council. Now, as we're aware, the prohibition against torture and other cruel, inhuman and degrading treatment and punishment is a widely recognised human right, but also widely infringed. And in Dr. Edwards' first 6 months as the UN Nations Special Rapporteur, Dr. Edwards has been, I think, inundated with allegations of torture and other forms of ill treatment from victim survivors. Now, in Australia, we like to think of ourselves as, well, we hope to think of ourselves as champions of the international human rights system and good players on the international stage. But we have recently, of course, attracted negative attention following the cancellation of the UN Subcommittee on the Prevention of Torture's official visit last year. And that was relating, as many of you know, because of the issues of obtaining access to places of detention. And it's a very rare occasion that a visit is cancelled in that way. So I think Dr. Edwards will ask us to think about, should this prompt a rethink about Australia, about the misalignment between, I guess, how our external posture is regarding human rights and this fundamental human right, and our internal practices here in Australia. So now that we're ready to begin, I'd like to introduce you to Dr. Edwards, who's joining us from in the very early morning in Oxford. Have I got that right, Alice? So,
yes, that's right, Melissa.
Late afternoon for us. But after 40 years of very male-dominated role of the Special Rapporteur on Torture, Dr. Edwards is the first woman and first Australian person to take up the role as she has. She's been an advisor to the UN and to many regional bodies, to governments, to national institutions and civil society, and has many, many publications that have influenced the way international law and policy and practice have evolved. She has developed groundbreaking legal arguments in various areas, including rape as a form of torture and persecution. And this has led to various important consequences, such as hundreds of thousands of women and girls to be able to obtain refugee status as a result. She's also at the forefront of many key developments at the UN in regards to alternatives to immigration detention and many other interventions that she has had in the international law process. I'm pleased to say that Dr. Edwards is an Australian qualified lawyer with degrees from the University of Tasmania, the University of Nottingham in the United Kingdom, and a PhD from the ANU. So if I can invite you, Dr. Edwards, to address us with your comments, and I'm hoping that people will, as we have previously, pop their questions into the chat box for us, and I'll be able to distill those to ask at the conclusion of the keynote. Thank you so much.
Ladies and gentlemen, it is a true honour to be joining you at Australia's preeminent human rights conference organised by the Castan Centre for Human Rights, which provides a platform for meaningful dialogue on crucial national and global matters. I'm grateful, Melissa, for the very kind invitation, and to all of you for your participation today. I acknowledge the traditional custodians of the land and their elders past and present. I also pay respects to Aboriginal and Torres Strait Island leaders and peoples attending today. Ladies and gentlemen, I'm speaking to you at a particularly dangerous time in world affairs. There are more conflicts in the world today than at any time since 1945, and multilateral affairs are split and heavy. The unlawful armed attack by Russia into the territory of Ukraine suggests an existential crisis for the United Nations, which was built as a forum of diplomacy to prevent such threats to international peace and security and to protect our human rights. The escalation of that conflict and others and lack of resolution is a big red mark. As a special rapporteur on torture and other cruel, inhuman, or degrading treatment or punishment, I have observed a corresponding rise in torture and other violence being perpetrated in many places. I have observed torture and cruel treatment in the conflicts in Mali, Haiti, Sudan, Yemen, and elsewhere. I'm particularly concerned by the prevalence of allegations of sexual violence. I recently sent inquiries to the Russian Federation regarding information I had received, which appears to show a consistent pattern and potentially state authorization of torture by Russian military forces. Elsewhere, we see police violence, sometimes fatal, fueled by a dangerous mix of heavily armed and technologically equipped police and increasing mobilization of social movements. Incidents have taken place in Chad, France, Iran, Kazakhstan, Nicaragua, Peru, Senegal, Tajikistan, and so on. Deaths at the hands of police in a number of countries, including in the United States of America, continue to raise alarm and call for a review of police leadership, recruitment, training, and responsibilities. The demands on police in some countries, including in Australia, to respond to call-outs for mental health emergencies have resulted in what appear to be unnecessary fatalities and serious injuries to persons with mental illness or dementia. The growing rate of incarceration in many parts of the world is also preoccupying for my mandate, for which I will be dedicating my next report to the UN's Human Rights Council. In this era of conflict and upheaval, what can those of us who respect human rights do? Turning to Australia specifically, I wanted today to investigate further into Australia's record of prohibiting and preventing torture and other ill treatment at home and abroad. Australia has long cast itself in the role as a good international citizen. So as a starting point, let's ask what makes a country a good international citizen. Gareth Evans, former Australian Foreign Minister and one-time candidate for UN Secretary General, described the concept as involving a moral imperative based on our common humanity. Evans identified three key returns that come with being a good international citizen. First, it provides an opportunity for progress on global and regional issues that require collective international action, even if they may not directly impact a nation's security or economic interests. Second, it fosters reciprocity, creating a collaborative environment where countries are more willing to help one another. And finally, being a good international citizen, he said, enhances a nation's reputation, attracting investment, trade, and partnerships based on trust and shared values. So the last, of course, a self-interested perspective that is part of the realpolitik. Now, to assess a country's record as a good international citizen, Evans proposed 4 benchmarks: foreign aid generosity, response to human rights violations, reaction to conflict and mass atrocities, and contributions to addressing global existential threats. From my perspective, there is an additional criterion, such that being a good international citizen requires an internal and external alignment of commitments. That means, concretely, that when a state undertakes human rights obligations, which are accepted voluntarily through agreements with other states, yet are applicable domestically as well, there should not be a mismatch between words and deeds. International standards set benchmarks against which states can assess their own performance as well as the performance of other countries. Participating in international fora, for example, through the Universal Periodic Review, requires a degree of self-reflection and self-awareness, It requires humility and admission when fault is found. And it also involves participation by calling out wrongdoing by other governments and offering technical assistance as needed. Failures at home lead to a loss of credibility and standing abroad. People in glass houses and all that. Only when both of those aspects are fulfilled, the internal and the external, can one gain the title of being a good international citizen. Ladies and gentlemen, the prohibition of torture is an erga omnes norm belonging to a select group of international human rights that are owed to humanity as a whole. The prohibition of torture is a foundational principle upon which democratic societies are based. It forms part of the social contract for which, in return for granting powers to govern, individuals are left to live freely and without interference, intimidation, or fear of the state. The associated obligation to take all necessary measures to prevent torture and other ill treatment demands more than mere rhetoric and promises. It requires legislation, regulations, procedures, training and capacity building, education and information, disciplinary measures, criminal proceedings, and practical action. So how does Australia fare against these benchmarks? Is the country living up to the principles of being a good international citizen vis-a-vis its obligations to prohibit and prevent torture and other ill treatment? Let me turn to Australia's external facing international commitments. In general, Australia presents as a strong participant and supporter of human rights. Australia's contributions to UN agencies and programs reflects its international humanitarian efforts, its commitment to international humanitarian efforts and willingness to support initiatives aimed at protecting and improving the lives of vulnerable populations around the world. In 2021, Australia contributed nearly 1.2 billion Australian dollars to the UN system in assessed, voluntary and other contributions, making it the 16th largest donor globally. It is the 12th largest donor to UN peacekeeping efforts. As of May 2023, Australia was serving in 3 different peacekeeping operations. Australia is also party to almost all of the main human rights treaties, including the Convention Against Torture and its optional protocol, as well as the International Covenant on Civil and Political Rights and the 1951 Convention relating to the status of refugees and its protocol, and was many times actively involved in their drafting. Australia generally reports to the treaty bodies on time, and it is a sponsor of many resolutions. Notably, the country served on the Human Rights Council from 2018 to 2020 and was an original member of the International Court of Justice, having ratified the statute in 1945. Judge Hilary Charlesworth replaced Judge James Crawford, 2 eminent Australian jurists, and Australia has had a continuous presence on the court since 2014. Australia is also active in the International Criminal Court. It was chair of the like-minded group in negotiating the Rome Statute. It has helped states to ratify and implement the statute and was a lead advocate for the adoption of a crime of aggression. Several Australians fulfill roles on the treaty bodies and special procedures. As mentioned by Melissa, I am the first Australian to occupy the position of Special Rapporteur on Torture, which is the 2nd oldest of all the independent expert positions. It is clear that Australia is an outward supporter of human rights, no matter the government of the day, and plays a constructive role in international bodies alongside other countries. In my many positions prior to this one, when engaging at the diplomatic level, I have always found Australian diplomats to be highly skilled, articulate, and helpful. There is a general commitment to ensure that international standards do not drop below previously agreed levels, and at times, Australia has demonstrated leadership on specific global challenges. However, like other states, it does not enjoy and sometimes does not accept criticisms by UN entities or from other countries. That is a good segue to turn to three particular areas touching on the international prohibition of torture, albeit looked at from the perspective of Australia's domestic front, what I promised you I'd do today. I will touch on three specific areas. First, Australia's record on domestic prosecution of international crimes, including torture. Second, its treatment of refugees and asylum seekers. And third, its framework or lack of in relation to independent inspection bodies as part of Australia's obligations to the optional protocol to the Convention Against Torture. In my role as the UN's lead role on tackling torture, I see the scale and extent of torture crimes being perpetrated by and being ignored by states every day and everywhere. For this reason, one of my priorities as Special Rapporteur and the subject of my most recent report to the Human Rights Council in March this year, I focused on the duty to investigate crimes of torture at the domestic level. It is my opinion that only through prosecutions can the cycle of impunity, the antithesis of accountable government, be broken. For too long, the burden of achieving justice has been pushed onto overloaded and inherently limited international courts and tribunals. Important as they are, international courts cannot be a substitute for national prosecutions. For investigating torture nationally is not only aimed at successfully establishing criminal liability in a handful of cases, it is also, and importantly, about healing for survivors and their devastated communities, about reforming accused arms of the state, and about re-establishing the state's lost legitimacy. Australia is one of 108 countries worldwide that has enacted an explicit crime of torture in its national law. Section 274 of the Commonwealth Criminal Code of Act 1995 mirrors the definition of torture in the Convention Against Torture, with one notable exception, that any crimes committed overseas require the consent of the Attorney General. A crime of torture is not simultaneously found in all state criminal codes, and I would encourage those affected states to rectify this deficit. In 2002, the Commonwealth Parliament also passed the International Criminal Court Consequential Amendments Act 2002 to amend the criminal code in order to incorporate international crimes recognised by the International Criminal Court into Australian law, namely war crimes, crimes against humanity, and genocide, of which torture belongs. With the exception of the trial of over 800 Japanese troops at the conclusion of World War II, and the unsuccessful trial of 3 ex-Nazis in the early 1990s, Australia has a poor record of prosecuting persons for international crimes. In terms of universal jurisdiction, Australia does have provisions in the Criminal Code that allow for the prosecution of international crimes committed anywhere in the world. However, the decision to exercise such jurisdiction requires, again, the consent of the Attorney General. And there is a lack of clear guidelines guiding his decision, which raises concerns about accountability and potential future accusations of politicization of decision-making in regards to particular cases. Elsewhere in the world, many countries, and more countries than ever before, are seeing the utility of universal jurisdiction as a way to ensure that torturers and other war criminals do not evade justice by hiding out in other countries. At the beginning of 2023, US President Joe Biden signed into law the Justice for Victims of War Crimes Act, opening the door in the US to investigations of war crimes committed overseas, even in cases where neither the accused nor the victims are US citizens. Following my report to the Human Rights Council, Denmark sent a bill on international crimes to Parliament. In May this year, France's highest court ruled that the country could try foreign suspects under the universal jurisdiction principle, green-lighting inquiries into two Syrians accused of war crimes and crimes against humanity. A German court in Koblenz has convicted a suspect in relation to the grotesque violence perpetrated against Yazidi women and girls in Iraq. Meanwhile, Canada and the Netherlands this year instituted proceedings before the International Court of Justice against Syria for failing to implement the Convention Against Torture, a pathway to a form of interstate justice for victims via Article 30, subparagraph 1 of the Convention Against Torture. This is only the second time this has been attempted in the ICJ's history. War crimes of torture are not limited to foreign perpetrators, and frankly, only when states are able to prosecute their own citizens for crimes will justice be fully done. Recent revelations of war crimes committed by Australian soldiers in Afghanistan may have shocked Australia, but I'm sure they did not shock Afghans. The Brereton report, released in November 2020, recommended investigations into war crimes committed by Australian soldiers. Defamation proceedings brought and lost by Ben Roberts-Smith reinforces the view that there are cases to answer. So far, however, I'm disappointed that only one soldier has been charged. The failure to hold public officials accountable for their actions sends a distressing message, undermining the very foundations of justice and perpetuating a culture of impunity, including in the Australian case among the armed services. I call on Australia to take immediate action to investigate, prosecute, and provide reparations to the victims of these grave human rights violations. Moving now to the second area of Australia's record on refugees. Australia, as a liberal democracy, stands out not for its presence, but for its absence of a Human Rights Act or a constitutional charter of rights. The dualist approach to treaty implementation requires incorporation into domestic legislation for international obligations to hold domestic force. While some states, notably Victoria, Queensland, and the ACT, have their own human rights acts, these acts do not apply to the Commonwealth Government, including federal officials involved in running immigration and refugee and security detention centres. I have long campaigned for the end to the policy of indefinite detention for asylum seekers and refugees. Now, as Special Rapporteur on Torture, I am speaking out against prolonged and unreviewable detention as enduring degrading or inhumane punishment or even psychological torture. The Committee Against Torture has expressed similar concerns regarding Australia's mandatory immigration detention, including the detention of children, overcrowding, inadequate healthcare, restriction on access to social services, high rates of mental health problems among detainees, and reports of excessive use of force and physical restraint. The committee has emphasised the need for Australia to implement its international obligations fully and provide sufficient safeguards against arbitrary detention. A range of cases have been brought before the UN's Working Group on Arbitrary Detention. The use of regional processing arrangements in Papua New Guinea and Nauru has drawn criticism from many international bodies over the years. They have been found to establish harsh and dangerous conditions. Recent developments have shown some progress. The implementation of the Medevac law in 2019 provided a legislative pathway for refugees and asylum seekers in offshore detention to be transferred to Australia for urgent medical care. Latest reports are not clear, but I understand that all asylum seekers have now been evacuated from Nauru, although I'm disappointed to learn that the government still plans to keep Nauru open as a deterrent. What we know is that dissuasive policies such as these are in violation of the obligations under the Convention Against Torture. You may have seen that only this week the United Kingdom passed its illegal migration bill, which foresees a similar stop the boats regime to Australia, with the plan to send irregular migrants and asylum seekers to the African landlocked country of Rwanda. Already the courts are clogged with affected cases. Just last month, the Court of Appeal deemed the policy unlawful. The United Kingdom should learn from Australia's experience, such that these arrangements, as you know too well, lead to long-term heartache for refugees and enduring headaches for policymakers and operators, and eventually need to come to an end. Other onshore concerns involve a lack of adequate safeguards for detainees with an adverse character finding or security assessment to meaningfully challenge their detention. And while the federal court may have ruled that the practice of detaining refugees and other unlawful non-citizens in hotels is within the bounds of Australian migration law, I am here to tell you that long-term detention or conditions not suitable to length of stay rub up against the obligations not to mistreat persons deprived of their liberty. As of April 2023, I'm informed that there are still over 1,100 people held in immigration detention facilities. A welcome positive is that there are no longer any children in these facilities, as I understand it. Over a decade ago, I was commissioned by the UN High Commissioner for Refugees to prepare a study on alternatives to immigration detention, in which I visited Melbourne and classed the commendable work being done there that allowed refugees and asylum seekers to live in the community as world leading. I was always confused by how a country with such effective programs that had very low absconding rates could simultaneously have no entry policies and such a harsh detention regime. Refugees are humans too, and not just that. 30 to 40% of refugees are estimated to be victims and survivors of torture. Many more are secondary witnesses of it. With the ending of refugees on Nauru, it is high time for the government to reevaluate its approach. Will the government's proposed Human Rights Act include a right to seek and enjoy asylum from persecution, mirroring Article 14 of the Universal Declaration on Human Rights? I wonder. Finally, I turn to the last of the areas I wanted to touch on today. As I've mentioned, signing up to international treaties is one thing, but such acts are only meaningful when accompanied by direct implementation. The struggles of a few Australian states to establish national preventive mechanisms as per obligations under the optional protocol to the Convention Against Torture, ratified by Australia in 2017, has been widely reported. Just to clarify for those not familiar, National Preventive Mechanisms, or NPMs, are independent visiting bodies established at the domestic level with the goal to prevent torture and ill treatment in places where persons are deprived of their liberty, and to make recommendations with a view to improving conditions and procedures. The optional protocol also establishes an international subcommittee which visits states to makes unannounced visits to any place of detention. It carries out about 8 to 10 country visits per year. Even with various extensions, Australia has yet to complete its implementation of this one aspect of the protocol. I congratulate those states that have, in fact, established their NPMs, the Commonwealth itself, as well as ACT, WA, NT, and Tasmania. For other states, you have to wonder what they have to hide. Australia signs international treaties all the time. As I started with saying, it is a party to most of the core global human rights treaties. Never before have I seen such a standoff between federal and state governments over a human rights norm of such international significance. A blow to Australia's international reputation for sure, The visit by the subcommittee in February this year was suspended whilst it was still in progress for what they describe as a lack of cooperation. The subcommittee called out Australia for violating a procedural obligation of the Convention. And when I refer to suspension, what that means in reality is that the 4 esteemed independent experts of the SPT left Australia without completing their mission. Since then, the subcommittee has decided to declare the visit a total cancellation. This is another strike against Australia's international reputation. As a cancelled visit, Australia is now alone alongside, the irony of it, Rwanda, the country where the United Kingdom is planning to send its asylum seekers. There are many issues in Australia's prisons and detention network too many to mention in this speech. But they point out the importance of monitoring as a preventive dimension. And in particular, I do want to mention a few areas. In particular, abuses that continue to occur at Australia's juvenile detention centres. At Dondale Youth Centre, there were reports of children being strapped to chairs and hooded, gassed in isolation cells and hogtied by officers. At the Ashley Centre, the Commission of Inquiry heard evidence that a former worker for whom the government paid compensation to his alleged physical and sexual abuse victims continued to work in Ashley for another decade. This is deeply troubling, especially in light of the fact that the age of criminal responsibility across Australian states is set extremely low, age 10. The use of spit hoods on children, now banned by the Australian Federal Police, are completely unacceptable and breach children's rights under the Convention on the Rights of the Child, and I consider spit hoods to be inherently degrading in violation of the Convention Against Torture. Efforts shall be taken for police and other authorities to protect their staff rather than hood the prisoners. The high number of children in detention, both on remand and after sentencing, is also deeply concerning. This is especially so in light of the fact that in 2002, the government released statistics showing that over half, 2022, the government released statistics showing that over half of all young people in detention were Aboriginal or Torres Strait Islander people. Overrepresentation of Indigenous people exists also in the general prison population. They account for 28% of the prisoner population in Australia, while making up just 3.3% of the general population. Over-policing and subsequent higher arrest rates experienced by Indigenous communities contribute to their over-representation in the criminal justice system. Since the Royal Commission report on Aboriginal deaths in custody was released in 1991, it is a tragedy of unspeakable proportions that over 500 Indigenous people have died in custody. All of these very serious issues would benefit from regular visits by independent state and federal visiting bodies and an occasional visit by the UN Subcommittee. These visits are intended to prevent such violations, which are caused by the concentration of power in the hands of prison officials and very few. And yet, here we are with a number of Australian states still waiting to set up these vital bodies. Let me conclude by saying that Australia, like all countries, must reconcile what it does on domestic soil with what it says on the international stage. Every country must be firmly committed to transparency in the pursuit of extinguishing torture. Ending torture is a worldwide goal, yet it cannot be achieved until every country plays their part and also addresses challenges at home. To be a good international citizen, one must do more than throw stones at other countries from inside the glass house. whilst hiding behind the sofa and pulling down the blinds, despite the wind and rain pouring in. Instead, Australia must engage meaningfully and maturely at home and abroad. That means reflecting on criticism, accepting shortcomings, building stronger, safer, and more integrated communities based on human rights, and looking after our most vulnerable members. Thank you very much.
Many, many thanks, Dr. Edwards, for a very piercing, accurate, and well thought through keynote. I do have a question for you, if I might ask it. You mentioned a couple of things that sort of raised something for me, and one was the role of the Attorney General in the mechanisms of accountability. So I wondered if you might have anything additional to add to that, but I wanted to frame that a little bit in context of a different question, and that is, you've now been able to review a number of different countries and see the problems and the way that the countries and governments address the problems and address their own responses to UN scrutiny and UN processes, and particularly the role of the special procedures arrangements. What do you think is the most effective trigger or effective mechanism that works to shift countries from, in specific areas being non-compliant and non-transparent and non-accountable, to the next stage, which is we've shifted, we've moved from that federal state debate, or we've moved from that lack of rights enforcement, or we've moved those objections that the prison authorities have put in place in closed or other people in charge of closed environments have put in place. What's the trigger thing that seems to shift either governments or public authorities or the people who are able to make those decisions to a change in attitude? Because we know it's not that they don't know what the obligations are. These are old and well-established obligations and human rights, as you said, they're most fundamental. What have you found has been the lever that moves things?
Great, thanks, Melissa, for those quick, thought-provoking questions. In terms of the role of the Attorney General, I think one of the challenges is the dual head of the Attorney General, having both a political and a legal role in the context of the Australian setup. Your neighbour next door, New Zealand, has a reservation to the Convention Against Torture in relation to the compensation obligation, which says it will only be granted according to at the discretion of the Attorney General, which is also a worrying feature. I think in many countries there are these challenges of so-called independent prosecutor officers or so-called independent attorney generals, and then the pressures that may be brought to bear one way or the other, the close relationship between the police and the prosecutor, the close relationship between, say, a military prosecutor and those. There are very good standards now about how to ensure independence of those bodies. But I've seen it as a real challenge also in smaller islands nations, where in fact the Caribbean have discussed whether in fact you need an independent, a separate special prosecutor for crimes being committed by state officials, that the ordinary prosecutor is not the one that is able to take up those actions. I think I would always encourage a country such as Australia to be thinking, well, how would this look if it was from another country where we consider the rule of law to be less robust? And then you suddenly sit back and think, wow, to exercise universal jurisdiction for a international war criminal, we need the AG to give the go ahead, or in the case of New Zealand, as I mentioned, for the Attorney General to offer the compensation that perhaps a court has indicated needs to be paid. In terms of you've asked the multi-million-dollar question, Melissa, on the question of the effective trigger. It's interesting, in my last position as head of Secretariat for the Convention Against Torture initiative, which was an intergovernmental initiative of 6 governments supported by 40 plus other governments at all different stages of development and from all different world regions. Australia was also a supporter of the Convention Against Torture initiative. That initiative decided not to go the name and shame route and purely deal on a state-to-state level about encouraging each other, looking at what had worked and what hadn't worked, with the view to making progress moving forward. And I do think for countries that are willing to be constructive and have a sense that they need to do and to improve their performance, that does work. The name and shame approach, which is the mainstay of the United Nations, isn't always the winning goal. And many times it can be at least short-term counterproductive. So certainly in the Australian context and other similar countries, certainly things like research and knowledge and understanding, expanding that, having different viewpoints being allowed to be presented. My research, as I mentioned, on alternatives to immigration detention, I spent a lot of time looking at the costs. And so in 2006, when the first report came out, no one was interested in the cost because the political statement of detaining people was greater than their worry about the budget. But fast forward to 2011, and after the global financial crisis, countries then did start paying attention, and citizens paid attention to the cost, the extravagant costs of keeping someone in detention rather than in these very effective alternatives to immigration detention. So I think one needs the full spectrum to know there's no one lever that will do it. There's no one lever for one particular country, but ultimately at the end of the day, sometimes it does simply require someone to stand up, show leadership and drive that forward. And my experience too is sometimes that leadership, and I've been calling on leadership since I started in this position, can start anywhere in the government apparatus. Sometimes you find that it might be the second secretary who comes up with a great idea and then is able to move that up because of their own passion and drive. You'd be surprised how often things start in random places because someone has a real interest in it. And someone sees the wisdom of changing practices, but it does really require leadership.
I feel like you must have infinite patience, but we'll probably talk about that offline one day. I do have a question from the floor, and this goes to the definition and use of torture. I'm conscious that we're hitting about nearly at closing time, but we perhaps might be able to answer this one relatively straightforward, in a straightforward way. This one is arising out of an ABC interview that people watched last week, and Tasmanian politicians and public servants have referred to restrictive practices at certain youth detention centres, and they've described these restrictive practices as appropriate. And what that really means is that children can be locked down in their rooms or their small pod, small living areas, and they can only speak to the supervising staff through barriers, and they can't control when the lights are on and off, etc. So, and they may not have access to education. So there's this kind of pacifying or ameliorating words being used particularly when we're seeing in youth detention, but maybe some other areas of detention, as you mentioned before, with mental health and psychiatric care and those kinds of places. How do we address this kind of use of this managerial language instead of really identifying the practices that are going on in these closed environments as being part of torture and inhumane treatment? The question is then asked at the end, can we say that on evidence it appears that OPCAT is contravened in these situations and there is unlawful ill treatment of children? and potential torture in this scenario I've described to you. Thanks, Val, for the question.
Great, really good question, because we do, and I have seen, and we've seen over the years, many countries try to use different nomenclature to describe what is essentially torture or ill treatment. Think to Guantanamo Bay and language around enhanced interrogation techniques. Think to the United Kingdom and the hooded men case, where they were using deep interrogation language, etc. So it's really important that no matter what something is being referred to, that one looks behind the language and asks really whether what is going on is causing severe pain or suffering for a particular purpose, and that is an open-ended list of purposes. So it could be purely for the purpose of pacifying, or it could be owing to staff shortages. So these are unacceptable purposes. So, you know, it's really important that we get to the bottom of what's really going on. I'd also like to say that cumulative forms of more, perhaps what might be perceived by some as more minor harms can lead to torture. So that's a well-established principle. So if a young person is being subjected to lengthy solitary confinement, plus a deprivation of access to meaningful activities on a daily basis, as well as, you know, being denied educational opportunities, one might be able to run a case that on a cumulative basis, they amount to either degrading treatment or cruel treatment, inhuman treatment, or even to the level of torture. The Nelson Mandela rules, which are the UN standards on the treatment of prisoners, state that the maximum period someone can be kept in their cell or in isolation is 22 hours on a daily basis, and 15 days in a row of that amounts to torture. So at the highest end, the problem we've found with this standard is that many states are now, rather than treating this as kind of the absolute outer maximum of what is acceptable behavior, and reading it in isolation of all the other provisions in the Nelson Mandela rules, which do say that persons should have meaningful activities to do, they should be able to work and be treated as any other ordinary workers in society, they should be able to engage in educational and other recreational activities, etc. States are really, and what I'm seeing in my role, is really using this as the minimum standard. And certainly for children, this is not allowed. So I would encourage, we just need for children in particular in care and in prison settings, we need to really institute this culture of care rather than this culture of punishment. I think that's really important. It's very different for children. It can really set them up to a lifelong difficult, and they've already had a pretty terrible early childhood. I would encourage people who are interested to, when I put out my call for submissions to my next report, which will be on current issues in detention and prison management, and I will include the refugee immigration piece, but also looking at prisons, to make submissions, because I hadn't expected to be preparing a report on detention, thinking that we had these good standards and, we've got a lot of writing on this, but actually there are really still, grave violations going on, and states either calling them something else or, rubbing really, really against the absolute outer limits of what's acceptable behaviour.
Thank you. And I take it that you might take the same view that we do, that submissions can be brief, they can be from an individual, they don't have to be you don't have to be attached to an organisation, you don't have to have written a whole PhD on the particular topic. So if someone like a member of our audience is interested in making a submission when the opportunity arises, they should just write in and make a submission, not worry too much about, the perfect submission with the perfect provenance, etc. Would that be right still for you?
Yes, that is the case. For the reports, the submissions, what I try to do is any that I'm kind of drawing from, I try my best to give credit to those submissions. Some rapporteurs don't and you know, just kind of cite the things, but I am doing that. If you have, in contrast, if you have allegations that you wish to bring to my attention, which are more case specific, individuals or groups of individuals of which you're working with them and have consent, that is a different procedure in which then I would write to the Australian government seeking a response and intervening. So descriptions of patterns, yes, for the report, individual cases to the allegations channel.
I'm sure anyone who hops on the website for the Special Rapporteur will be able to find the correct procedural arrangements and the correct forms and opportunity to contribute there. Look, thank you, Dr. Alice Edwards, for joining us. I know it is early and I hope you can get on with the rest of your day without being too disrupted. I would like everybody to join me virtually and tangibly in thanking Dr. Edwards for her keynote today, and that will bring this session to a close.